So, with my lord's permission, my lord, prior to the break, your lordships had seen the stand of the state, my lords. Prior to, my lord, the arguments earlier, my lord, I had tried to point out to my lords the specific stand taken by the state government, my lord,
Proportionate
with regard to proportionate
reservation. Proportionate reservation, which has been,
already
virtually
struck down, my lords, and held
struck
to
down by Supreme Court. It
by
has to be adequate.
my lords. Now, my lord, the bedrock of the submission of the state to sustain the constitutional validity of the impugned provision is a report which is popularly called the Mahajan Committee's report, Mahajan Commission's report, my lords,
Where is
which
that?
they have filed as annexure R3. Lords. In that spiral bound report, my lords would have it.
No, this is what? On which point?
My lord, this is what they say. I'll just point out from the return also, where they refer to the Mahajan Commission's report, my lords. That on the basis of this report, they have decided to enhance the reservation to 27%. My lord, we come to
Well-
para 24 to 26 of the return.
Return. ये वाला. Para 26.
24 minutes.
24.
Minutes. May I read 24 minutes?
Yes.
It is submitted that initially the state of Madhya Pradesh appointed a state level commission under the chairmanship of Sri Ramji Mahajan, which is known as Mahajan Commission. The members of Mahajan Commission inquired in almost all the districts of the state of Madhya Pradesh about the status of other backward classes in the state. The commission inquired about the social and educational status of other backward classes. And after making a detailed inquiry as to the social, educational, and economic status of other backward classes, a detailed report was submitted by the Mahajan Commission before the state government. In the report so submitted, the Mahajan Commission recommended for grant of 35% of reservation in favor of other backward classes. At this juncture, it will not be out of place to mention here that the Mahajan Commission, after due physical verification, took note of the fact that the entire population of other backward classes in the state of Madhya Pradesh is more than 50%. And the aforesaid population is socially, economically, and educationally backward. And as such, the Commission recommended various steps required to be taken for the purpose of upliftment of other backward classes. Amongst other recommendations, it was recommended that minimum 35% of reservation should be granted to the other backward classes. The report is annexed R3 notes. Then para 25. It is submitted that the answering respondents are already in possession of detailed survey along with quantifiable data prepared by Mahajan Commission in respect of other backward classes. The aforesaid data was collected by the Commission after due physical verification of every district of Madhya Pradesh, and as such the aforesaid data deserves to be relied upon for all purposes so far as the question regarding welfare of other backward classes is concerned. In addition to the aforesaid, it is also then it goes on to other aspects, my lords. Now, my lord may have the report for a moment, my lords. It is annexure R3, which starts from page 36. And it is the submission of the state is that this is the quantifiable data collected by Mahajan Commission report, and the commission having recommended 35% of reservation, they have granted only 27%. My lords have page 36.
Yes.
Lord, at the left hand side bottom, my lords would find the date of the commission's report. My lord, the report is December 1983. So in fact, this is prior to Indira Sahni, 10 years prior to Indira Sahni almost. And it is for this reason, my lord, that this report seeks to rely upon various judgments which have been declared to be not good law anymore in Indira Sahani, and on those judgments this report bases its recommendations. But I'll straight away take your lordships, my lord, through to the relevant portion now. Now, what is stated in the return in para 24, 25 and 26 is that this is quantifiable data, my lords. I have made, my lord, my efforts to go through the length and breadth of the report. There is no quantifiable data at all.
When you say quantifiable data, what does it mean?
My lords, the
Has
concept,
it been defined somewhere?
my lord, the concept of quantifiable data came forth in Nagaraj, my lord, for the first time. Now, my lord may just have.
How has that been explained?
No. My lord may just come to para 122 and 123 of Nagaraj, my lords. The citation is 2006 volume 8 SCC, page 212.
Citation again?
My lord, 2006 volume 8 SCC, page 212.
What is the para?
My lord, para 122, your lordship may just come to.
Yes.
May I submit, my lord, that Nagaraj was a case which was dealing with reservation within 50%. The change in quantum of reservation within 50% for SC/ST categories. Now, in 122, my lord, it says that we reiterate, may I read, my lord, 122? We reiterate that the ceiling limit of 50%, the concept of creamy layer and compelling reasons, namely backwardness, inadequacy of representation, overall administrative efficiency, are all constitutional requirements without which the structure of equality of opportunity in Article 16 would collapse. However, in this case, as stated above, the main issue concerns the extent of reservation. In this regard, the state concerned will have to show in each case the existence of compelling reasons, namely backwardness, inadequacy of representation, and overall administrative efficiency before making provision for reservation. As stated above, the impugned provision is an enabling provision. The state is not bound to make reservation for SC/STs in matters of promotion. However, if they wish to exercise their discretion and make such provision, the state has to collect quantifiable data showing backwardness of the class and inadequacy of representation of that class in public employment in addition to compliance of Article 335. It is made clear that even if the state has compelling reasons as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling limit of 50% or obliterate the creamy layer or extend the reservation indefinitely. So, my lord, it is here that the concept of quantifiable data gets introduced. To say that the quantifiable data, my lord, would be for the purpose of showing backwardness of the class, inadequacy of representation of the class in public employment. This has been further explained in Indra Sahani, in Maratha reservation. Lord, I'll come to those relevant portions also.
Yes.
Now, my lord, therefore, once the state puts forth the stand that it is the commission's report which has collected quantifiable data, that quantifiable data A must be to sustain reservation within the limit of 50%. Because para 123 specifically says, my lords, that even if there are compelling circumstances which require enhancement of reservation, my lords, on the basis of quantifiable data, it still has to remain within the limit of 50%. Lord. It can't be, that quantifiable data can't be used to exceed 50%.
Yes, yes.
My lords. So, my lords, the respectful submission is that this report annexure R3 would be totally irrelevant in view of para 123 for granting reservation in excess of 50%. It would have been justifiable, my lord, had the reservation been increased from 47 to 48 or 49%. But it can't be used for crossing 50%, my lord, even if it is presumed that this contains quantifiable data. But, my lord, my submission goes beyond that, that this report does not contain even the quantifiable data as is referred to in paragraph 123 of Nagaraj. My lord, may I have the report for me?
Yes, yes.
My lord, this is the foundation, my lord. My lord, the report starts from page 36. From page 1 to page 230, there is no data. It is all discussion which goes into the realm of the religious texts from Manusmriti to Mahabharata, Ramayana, refers to everything. There is no data in the first 230 pages. So, my lord may straight away come to where they have started discussing the relevant portion, lords, which is from that your lordships would find, my lord, in running page 269. It is page 231 of the report. But my copy is not very legible, my lord. So may I just request, my lord, my friend to
269.
lords. 269. अध्याय 12
आरक्षण
साक्ष्यों
के
की विवेचना.
ऐतिहासिक पृष्ठभूमि.
Lord, this is अध्याय 12 page 269 साक्ष्यों की विवेचना.
269 is there is no heading.
Lord, I am sorry then. My lords are referring to the running page within the report, my lords? No, my lords, I am referring to the paging of the return. This would be running page 230. Internal paging 230.
Internal page 230 is some dates are there.
My lords, I'll just point out. Your lordships have the return of
230 अध्याय 11. हाँ?
अध्याय 12 है.
11 12.
12 है साक्ष्यों की विवेचना.
No, this is सामाजिक एवं शैक्षणिक पिछड़ापन निर्धारण के मापदंड.
Perhaps page 269, that's the running page of the return.
The running page of the return, Lord, in
In
Ashita.
5901.
5901.
269.
269.
Slightly better than my.
Our copy is slightly better, but my learned friend can read.
My lords have
269.
internal page.
साक्ष्यों का विवेचन.
साक्ष्यों का विवेचन.
12. Yes.
I'm not pausing here, my lord, if my lords would permit. 123 of Nagaraj, when it says that there must be quantifiable data with regard to backwardness and inadequacy of representation, it must be statistical data collected from across the state, various departments, statistical agencies. A, with regard to the representation of the community in the educational institutions. B, with regard to employment, my lord, to have it relevant for both Articles 15 and 16 of the Constitution of India. Now, what the Commission has done, my lord, its methodology is disclosed in this opening paragraph of Saksho Ka Vivechan, para 12, chapter 12. May I read, my lords?
Yes.
आयोग ने पूरे प्रदेश में सर्वसाधारण नागरिकों, स्वैच्छिक व सामाजिक संगठनों, सामाजिक कार्यकर्ताओं आदि से पर्याप्त मात्रा में साक्ष्य एकत्रित किए हैं. आयोग ने पूरे प्रदेश में दौरा भी किया है और जिला मुख्यालय, कई तहसील व विकासखंड मुख्यालय में कई ग्रामों में जाकर पिछड़े वर्गों को संपर्क कर उनकी समस्याओं को नज़दीक से देखा है, बैठकें आयोजित कर उनकी समस्याएं सुनी, लोग उपस्थित हुए, probably that is what is mentioned। दौरे के समय आयोग के समक्ष भारी संख्या में पिछड़ा वर्ग के लोगों ने अपनी जाति व वर्ग के के संबंध में विस्तृत जानकारी उपलब्ध कराई। पिछड़ा वर्ग के सामाजिक संगठनों व नागरिकों द्वारा आयोग को जानकारी भेजने बाबत प्रश्नावली। आयोग ने 75 प्रश्नों की एक प्रश्नावली सामाजिक संगठनों व नागरिकों के द्वारा भरकर भेजने हेतु जारी की, जिसे स्वयंसो के खंड में दो में दर्शाया गया है। इस प्रश्नावली के प्रश्नों को सामाजिक, आर्थिक, शैक्षणिक या राजनैतिक 4 भागों में बांटा गया है। So this is the methodology which is adopted, my lords. What is the sample size with which the commission was working? To how many people this questionnaire of 75 questions was provided? Whereas all the departments of the state were at the discretion and available to the commission, my lord, it could have had all the statistical data made available. But it chose only to go to the persons or institutions belonging to the backward classes, delivered them questionnaires and asked them specific problems as to what is the issue that you are facing and collected data on that basis. So there is no pan state, pan class assessment to meet the parameters under para 123 of Nagraj.
Yes.
Then, my lord, सामाजिक स्थिति, नेक्स्ट पैराग्राफ। किसी वर्ग, समूह या जाति के सामाजिक स्थिति जानने हेतु प्रश्नावली के 27 प्रश्न निर्धारित किए गए हैं, जिससे जाति का नाम तथा उसकी जाति के विभिन्न क्षेत्रों में जाने वाले उपनामों की जानकारी चाही गई। प्रश्न क्रमांक 3 के द्वारा इसे जाति समूह व वर्ग द्वारा अपनाया जाता रहा। परंपरागत व्यवसाय कौन सा रहा है, इसकी जानकारी चाही गई। इसके द्वारा ज्ञात हुआ कि एक जाति, वर्ग व समूह द्वारा अपनाया गया परंपरागत पैतृक व्यवसाय तो एक ही है, लेकिन एक ही जाति, समुदाय या वर्ग के विभिन्न क्षेत्रों में जाने वाले मतलब स्वयंसो वाला नाम व उपनाम पृथक है। इसका आयोग ने पिछड़े वर्ग की जाति सूची को वर्गीकृत करने में उपयोग किया है। दिस इज द मोड ऑफ क्लासिफिकेशन, नोट्स। देन दे गो टू हीन पेशे के कारण सामाजिक भेदभाव। दिस इज द फर्स्ट कैटेगराइजेशन and they have made various classes, my lord, categories under which they have worked. I'll straight away come to, my lords, the final part, my lord, where the commission deals with all this material which it seeks to collect. It is not statistics essentially which is collected. It is opinion collected on the basis of 75 questions, my lords, of individuals who belong to that very class for whom the commission was working on to provide reservation units. Lords, my lords, may come to chapter 15, lords. That would be at running page 306, internal page 268 of the report. I'll just take, my lord, I won't read all this part, my lord. Just take, my lord, summarily through everything.
264, internal page.
My lord, the running page in the return is page 306. 268 is the page where chapter 15 starts.
Chapter 16 or 15?
15 minutes.
15. Yes. Yes.
But here also your lordships would find, Lord, that there is no statistical data as such which is being taken into consideration. But the condition under in various states and all that, Lords, as to what is the status of the backward classes in various states. Then chapter 16 at page 278, where शैक्षणिक पिछड़ापन को समाप्त करने के प्रभावी उपाय. My lord, may straight away come to running page, my lord, internal page 282. Where the discussion starts.
Running page?
My lord, internal page 282. The returns page would be, my lord, page 320. No data, my lord. It is essentially a running.
Hmm.
Lord, those words are probably not to be.
Yes.
282 minutes. Second paragraph. The commission relies upon certain judgments, my lord, to come at its final conclusions.
Hmm.
उच्चतम न्यायालय ने केरल राज्य बनाम
Hmm.
एनएम टॉमस, माय लॉर्ड्स हैव इट,
Yes.
एआईआर 1976 सुप्रीम कोर्ट 490 के मामले में महत्वपूर्ण निर्णय देते हुए कहा कि आरक्षण का प्रतिशत 50% से अधिक नहीं होना चाहिए. यह नियम सावधानी बरतने के लिए है और यह सभी प्रवर्गों को लागू नहीं होता है. न्यायाधिपति मुर्तजा फजल अली ने कहा. मिलॉर्ड, देन द डिस्कशन गोज ऑन. The citation, not the SCC citation, if your lordships would want to note, is 1976 to SCC page 310. Notes.
Hmm.
Lord, these two judgments are heavily relied upon by the commission.
Which is the other judgment?
The other judgment is the Akhil Bharatiya Shoshit Karmachari Sangh Banam Bharat, Union of India. That is 1981, volume 1, SCC, page 246. It would be on the next page. And the commission labors under the impression that the 50% rule propounded by M.R. Balaji earlier in 1963, my lord, Supreme Court, has been diluted by these two judgments, and therefore they are making recommendations for OBC reservation to cross 50%. That is the thrust of this part, notes. My lord, may just have page 282, bottom 5-6 lines. And the commission is also working on proportionate representation rather than adequate representation.
Yes.
My lords, have page 282, bottom 4-5 lines.
20?
282, my lords.
Yes.
Where the judgment in state of Kerala versus N.S. Thomas is being read, lords.
Yes.
Udaharan, in brackets it is mentioned Udharanarth. My lords, have it?
Yes.
Lords. यदि यह मान लिया जाए कि किसी राज्य के नागरिक ने अपने अनेक पिछड़े हुए वर्ग, जो कि जनसंख्या में 80% हैं, और सरकार उन्हें उचित प्रतिनिधित्व देने की दृष्टि से उनके लिए 80% आरक्षण करती है, तो क्या यह कहा जा सकता है कि आरक्षण का प्रतिशत अनुचित है और वह अनुच्छेद 16 के खंड 4 के अनुज्ञेय सीमाओं का अतिक्रमण करती है? इसका उत्तर आवश्यक रूप से नकारात्मक ही होना चाहिए. That means the commission believes that there can be 80% reservation also. इस उपबंध का मुख्य उद्देश्य अपर्याप्त प्रतिनिधित्व को पर्याप्त बनाने के लिए कदम उठाना है. उच्चतम न्यायालय ने इस मामले में 68.5% आरक्षण को वैध करार दिया और बालाजी के मामले में निर्धारित इस सिद्धांत का कि आरक्षण 50% से अधिक नहीं होना चाहिए उलट दिया है. उच्चतम न्यायालय ने अखिल भारतीय शोषित कर्मचारी संघ बनाम भारत संघ AIR 1981 सुप्रीम कोर्ट 298 के मामले में भी बालाजी बनाम मैसूर राज्य के मामले में अभी निर्धारित सिद्धांतों को कि आरक्षण की सीमा 50% से अधिक नहीं हो सकती है रद्द करके सिद्धांत दूसरा निर्धारित किया है. इस संबंध में न्यायमूर्ति कृष्णा अय्यर ने निम्न विचार व्यक्त किया है. यदि कुछ अधिक नियुक्तियां हो जाती हैं तो उन पर प्रभाव नहीं पड़ेगा, क्योंकि गणितीय निश्चितता मानवीय कार्यकलापों में कठिन होती है. Now, my lords may just have for a moment, my lords, para 381.
No, both these decisions,
My lords.
this is Akhil Bharati Shoshit Karamchari Banam so and so and
And S.N. Thomas, my lord.
N.M. Thomas.
N.M. Thomas, my lord, I'm sorry.
What has this 9-judge bench said about these two cases?
Indra Sahni, my lords. My lords. I'll just come to that, my lords. My lord, Balaji said 50%. That is how the concept of 50% came into existence. These two judgments said that they could exceed 50%, my lords, and that 50% is probably not a binding limit. My lord, that is what was sought to be suggested. Not to come straight away to what Indra Sahni said about these two. My lords may have page para 381 of Maratha Reservation. 381. Or if your lordships have Nagraj, my lords have Nagraj.
We have all three.
My lord, in Nagraj, my lords may just have para 57 and 58. My lords have para 57 of Nagraj. That would be at page 251.
Yes.
May I read? But in state of Kerala versus N.M. Thomas, Krishna Iyer J expressed his concurrence with the view of Fazal Ali. Fazal Ali was in that matter, who said that although reservation cannot be so excessive as to destroy the principle of equality of opportunity under clause 1 of Article 16, yet it should be noted that the Constitution itself does not put any bar on the power of the government under Article 16(4). If the state has 80% population which is backward, then it would be meaningless to say that the reservation should not cross 50%. That is what the judgment said, my lord, in Thomas. 58. However, in Indra Sahni, the majority held that the rule of 50% laid down in Balaji was a binding rule and not a mere rule of prudence. Giving the judgment of the court in Indra Sahni, Jeevan Reddy J stated that Article 16(4) speaks of adequate representation, not proportionate representation, although proportion of population of backward classes to the total population would certainly be relevant. Now, my lord may just come to para 381 of Maratha.
Yes.
Lord, this is further clarified in Maratha. With regard to both judgments, my lord, N.M. Thomas and Akhil Bharti. May I read it? 381 minutes. That is at page 215 minutes.
50.
215 minutes.
Yes.
It reads, my lord, the judgments of this court in N.M. Thomas and Akhil Bhartiya Soshit Karmachari Sangh, the state of Punjab, and even dissenting judgment of Krishna Iyer J in Devdasan and Akhil Bhartiya Soshit Karmachari Sangh have been referred to and considered by the 9-judge constitution bench of this court in Indra Sahni. In Indra Sahni, B.P. Jeevan Reddy, while considering question 6, noted M.R. Balaji, Devdasan and N.M. Thomas, and concluded that reservation contemplated in clause 4 of Article 16 should not exceed 50%. After considering all the above cases, which according to Shri Rohatgi are discordant notes, a larger 9-judge constitution bench having held that the reservation contemplated in clause 4 of Article 16 should not exceed 50% of the earlier doubt raised by the judges as noted above cannot be relied on any further. The larger bench in Indra Sahni has settled the law after considering all the earlier decisions of this court as well as reliance of the opinion of few judges as noted and as relied on by Shri Rohatgi is of no avail and cannot furnish any ground to refer the judgment of Indra Sahni to the larger bench. Then, Lord, one more judgment that is on quantifiable data. It goes on. Let's para to it. So, what was held by the bench judgment, Lord, that neither Thomas nor Akhil Bhartiya would now hold field in view of the larger 9-bench judgment in Indra Sahni, which says 50% is the rule. And the only exception to 50% would be as carved out in para 810 of Indra Sahni itself. Your Lordship may just come back to the report notes. Page 283. My lords have 283.
283.
Internal page of the report 283.
Yes.
Where Shoshit, Akhil Bharatiya Shoshit Karmachari Sangh is referred.
Hmm.
Third paragraph from the top. उच्चतम न्यायालय ने अखिल भारतीय शोषित कर्मचारी बनाम भारत संघ IR 1981 सुप्रीम कोर्ट 298 के मामले में भी बालाजी बनाम मैसूर राज्य के मामले में अभिनिर्धारित सिद्धांत को कि आरक्षण की सीमा 50% से अधिक नहीं हो सकती रद्द करके सिद्धांत दूसरा निर्धारित किया है। इस संबंध में न्यायाधिपति कृष्णा अय्यर ने निम्न विचार व्यक्त किया है, यदि कुछ अधिक नियुक्तियां हो जाती हैं तो उसका प्रभाव उनसे प्रभाव नहीं पड़ेगा क्योंकि गणितीय निश्चितता मानवीय कार्यकलापों में कठिन होती है। न्यायाधिपति चिन्नापर रेड्डी ने इस मामले में कहा है कि अनुसूचित जातियों अनुसूचित जनजातियों के पक्ष में आरक्षण या अधिमानी व्यवहार के लिए कोई अधिकतम सीमा तय नहीं है। 50% की नियम के बारे में कोई कठोरता नहीं है। So my lord, this is the presumption that the commission is working with, that there is no such rule as 50% rule, my lord, which, and if the population proportion justifies, then it can be breached, my lords. My lord, may just skip over this paragraph and come to the last paragraph on this page, my lords. आरक्षण संबंधी मात्र बालाजी बनाम मैसूर राज्य के मामले में लगाई सीमाबंदी अनुच्छेद 15(4) एवं अनुच्छेद 16(4) के अलावा गैर पिछड़े वर्गों को कुछ सामान्य श्रेणियों के लिए किए गए आरक्षण लागू नहीं होगा। इस संबंध में सुभाषनी बनाम मैसूर राज्य सोएंसो, माय लॉर्ड में हैव जस्ट द लास्ट 3 लाइंस, माय लॉर्ड, इस तर्क को अस्वीकार करते हुए, योर लॉर्डशिप हैव इट, माय लॉर्ड, 3 लाइंस, अस्वीकार करते हुए निर्णय दिया कि सामाजिक तथा शैक्षणिक दृष्टि से पिछड़े वर्गों के लिए स्थानों के आरक्षण की वैधता का निर्धारण अनुच्छेद 15(4) में निर्धारित शर्तों के अनुसार किया जाना चाहिए। सामाजिक तथा शैक्षणिक दृष्टि से पिछड़े वर्गों, अनुसूचित जातियों और अनुसूचित जनजातियों के ऊपर वर्गों के लिए किए गए आरक्षण की वैधता का निर्धारण अनुच्छेद 14 के अपेक्षाओं के आधार पर किया जाना था। इस प्रकार आरक्षण अनुच्छेद 15(4) के अधीन किए गए आरक्षण के साथ मिला नहीं देना चाहिए। बालाजी के मामले में then that data comes with regard to Tamil Nadu, milords, where in Tamil Nadu the reservation was 68%, and in Karnataka, milord, it was said to be 66%. Then the recommendation of the commission comes, milords, in the paragraph below. मध्य प्रदेश में पिछड़े वर्गों, अनुसूचित जातियों एवं अनुसूचित जनजातियों की हालत बहुत ही दयनीय है। इनका प्रतिनिधित्व मेडिकल, इंजीनियरिंग, वेटनरी, आयुर्वेदिक, कृषि महाविद्यालयों तथा अन्य तकनीकी व व्यावसायिक शिक्षण संस्थाओं में नगण्य है। देयर इज नो डेटा टू दिस इफेक्ट, मिलर्स, इन द रिपोर्ट। अधिकांश पिछड़े वर्गों, जातियों, वर्गों के छात्रों की संख्या उक्त महाविद्यालयों में शून्य है। इस प्रदेश में विशेष परिस्थिति है, इस प्रदेश की विशेष परिस्थिति है, इसलिए आयोग तमिलनाडु राज्य द्वारा लागू की गई आरक्षण व्यवस्था को उचित मानते हुए अन्य पिछड़े वर्गों के छात्रों के लिए मेडिकल कॉलेज, इंजीनियरिंग कॉलेज, वेटनरी कॉलेज, आयुर्वेदिक महाविद्यालय, कृषि महाविद्यालय, विज्ञान एवं विधि महाविद्यालय, तकनीकी एवं व्यावसायिक शिक्षण संस्थानों इत्यादियों में प्रवेश के लिए 35% स्थानों के आरक्षण की अनुशंसा करता है। विधि महाविद्यालयों में प्रवेश के लिए 40% से कम अंक प्राप्त करने पर वाले छात्रों को विशेष मिलोट, then it goes on for other things. So the recommendation milote as referred to in the return with regard to 35% once finds place it here milote, later on it comes at other places also. My lord may just turn over the page milote, where this is sought to be correlated with the population groups. At page 285 मिनट सेकंड पैराग्राफ, इस प्रदेश में पिछड़े वर्गों की आबादी 48.08% है। आरक्षण व्यवस्था पिछड़े व कमजोर वर्गों के लिए उनकी आबादी के अनुसार करने का सिद्धांत है। दिस इज द प्रिजम्पशन नॉट दैट द कमीशन इज लेबरिंग अंडर, दैट देयर इज प्रोपोर्शनेट रिप्रेजेंटेशन कॉन्सेप्ट, रिजर्वेशन कॉन्सेप्ट। आबादी के अनुसार उनका आरक्षण 48% होना उचित है, लेकिन मेडिकल कॉलेजों और शासन अनुसूचित जातियों को 15% तथा अनुसूचित जनजातियों को 15% स्थान आरक्षित कर रखा है। इसलिए यह आयोग पिछड़े वर्ग के लिए 35% स्थान आरक्षण करने की अनुशंसा करता है। Then Lord's chapter 17, which is at page 288, then again goes on to rely upon the same judgments, my lord, of Thomas and Akhil Bharatiya Shoshit Karmachari Sangh at various places, my lord. I would not take your lordship through, my lord, all that. But then essentially it is all reproduction of various portions of the judgments in those cases. There is no data. The final part, my lords, would find कि आरक्षण की मात्रा क्या हो is from page 308 minutes.
Yes.
My lords have, आरक्षण की मात्रा क्या हो?
Yes.
भारतीय संविधान में आरक्षण की क्या सीमा व प्रतिशत हो, इस संबंध में कोई प्रतिबंध नहीं लगाया गया है। Not probably because this is written in 83, Indira Sahni had not come by that then, and Balaji was sought to be doubted by those two judgments. Under that presumption, all this is being written. अनुच्छेद 16 के खंड 4 के अधीन आरक्षण करने संबंधी सरकारी शक्ति का कोई सीमा नहीं लगाई गई है। इसके लिए उच्चतम न्यायालय केरल राज्य में, सेम जजमेंट इज बीइंग रिलाइड अपॉन। माय लॉर्ड में टर्न ओवर द नेक्स्ट पेज and come to page 309. The same thing, Lord, as in page 320 कि 80% यदि जनसंख्या होगी तो क्यों ना 80% आरक्षण दे दिया जाए, और इसका उत्तर नकारात्मक नहीं हो सकता। That is what is said. It is the same as it is in page 320. The opening paragraph of page 309.
Yes.
Note again in the third paragraph it is said that the 50% rule has already been overturned. उच्चतम न्यायालय ने केरल राज्य बनाम NM टॉमस में मामले में 68.6% आरक्षण को वैध करार दिया है। इस प्रकार MR बालाजी बनाम मैसूर राज्य AIR 1963 इट शुड बी 1963 सुप्रीम कोर्ट 649 में अभिनिर्धारित सिद्धांत को कि आरक्षण 50% से अधिक नहीं होना चाहिए, उच्चतम न्यायालय ने केरल राज्य बनाम SN थॉमस में मामले में उलट दिया गया है। Then Akhil Bharati is relied upon. My lord, may come to the final recommendations part. Again, that Tamil Nadu statistics is referred to. The population, my lord, which is probably the only part of data which comes through, is at page 313. My lords have 313 minutes.
3.
My lord, the reports paging 313. 313 minutes.
Yes.
At the bottom, my lords would have Madhya Pradesh में आयोग द्वारा संकलित और तैयार की गई सन 1981 की जनगणना के आधार पर वर्ष 1982 में अनुसूचित जातियों, अनुसूचित जनजातियों, अनपिछड़ा वर्गों का प्रतिशत निम्न है. And then the data of population is provided, which says OBC is 48.08%. Then on the next page, my lord, the reservations. And then after giving that reservation, my lord, up to 36%, that is what is said. For SC and ST, तमिलनाडु में पिछड़े वर्गों, अनुसूचित जातियों, अनुसूचित जनजातियों के लिए आरक्षण अनुच्छेद 16(4) के अंतर्गत 68% है, जहां पर आरक्षण व्यवस्था 100 वर्ष से लगातार चालू है. देन एट द बॉटम में लॉर्ड ओनली वन लाइन, सामाजिक एवं शैक्षणिक दृष्टि से पिछड़े वर्गों के लिए मध्य प्रदेश में पिछड़े वर्गों की जनसंख्या के अनुपात में आरक्षण के हकदार हैं. सो दिस इज द रीजन विच इज गिवन बाय द कमीशन लॉर्ड, दैट दे आर एंटाइटल्ड टू रिजर्वेशन ऑन द बेसिस ऑफ प्रपोर्शन इन पॉपुलेशन. Then again, my lord, elaborate discussion on all the judgments, which I will skip over, my lords. The recommendations, finally, would start, my lords, from, my lord, just come for a moment, my lord, page 322, internal page 322.
Yes.
The third paragraph, my lords, उपरोक्त संदर्भ में आयोग अन्य पिछड़े वर्गों के लिए शासकीय, my lords have it, my lords, शासकीय, अशासकीय तथा अन्य क्षेत्रों में उपलब्ध सेवाओं में निम्नलिखित आरक्षण की व्यवस्था की अनुशंसा करता है. Then para 1, Lord, the one below, just Lord, the para which starts with पिछड़े वर्गों को उनकी जनसंख्या के अनुपात में आरक्षण 48.08% अपेक्षित है. आयोग संविधान की सभी पहलुओं, न्यायालय के निर्णयों व तमिलनाडु अन्य राज्यों के उदाहरण को ध्यान में रखते हुए समस्त शासकीय, अर्धशासकीय एवं सार्वजनिक संस्थानों को की सेवाओं में पिछड़े वर्ग को 35% आरक्षण प्रदान किए जाने की सिफारिश करता है. This is also, my lords, laid down in chapter 19, which would be which starts from page 336 minutes.
Yes.
It's the same thing, my lord, 35%
Yes. Yes.
in proportion to population. Page 336 and 338 are the two relevant pages, my lords.
Yes.
336 is with reference to educational institutions, my lords, and 338 is with reference to employment.
Yes. Yes.
So, my lord, my respectful submission is that the commission is also moved by the fact that there is no bar of 50% and that the OBC community is entitled to reservation in proportion to their population. So it is going on proportionate reservation and proportionate representation rather than adequate representation. And the criteria laid down in para 123 of Nagraj with regard to quantifiable data, which though would not be relevant to exceed the limit of 50% as per that paragraph itself,
All right.
is also not totally missing.
So what happened to this report in 83?
But
It was not given effect to.
that is not what we are given to understand, that till date it was never given effect to.
Right.
It's only now, once they made the reservation and they had to justify it before this honorable court, they've come up with this, to say that our reservation is based on this. My lord may also have that they are moved by the proportion of the population in the statement of objects and reasons of the offending act also. My lord may just have that minutes for a moment.
Which act? The 94 Act.
For act, my lord, as it stands amended by the impugned amendment, my lords. My lord may have the amending act only. It is P6 in the return, my lords. P6 with my petition.
हाँ? इंदिरा 93 में है ना, 92 में ये 92 है, 92 इंदिरा ठीक है। मैंने कहा इसकी कंट्रोवर्सी शुरू कब हुई थी? 90 ये कंट्रोवर्सी शुरू नहीं होगी, इसलिए ये बैठ कर
यही है ना?
इसका ही चारों तरफ शुरू हो गया।
My lords have the act, my lords.
Yes.
My lord, just have the statement of, but it would not be there in the book, my lords, because the book has the amendments, but not the amending act. I am referring to the amending act, my lords, of 2019. my lords. Lord, this is मध्य प्रदेश लोक सेवा अनुसूचित जातियों, अनुसूचित जनजातियों और अन्य पिछड़े वर्गों के लिए आरक्षण संशोधन विधेयक here, my lord, then it became अधिनियम 2019. My lords have it?
Actually, the Mandal Commission was constituted sometime in 79 as per this judgment.
Indira Sahni.
So that must be sitting at that time when this 83 report.
My lords, probably.
So they did not give effect to this. They must have
They
waited
would have
for the
waited for
Mandal.
my lords.
Yes. Shodhan Adhiniyam to in the act, the petition hai, I think.
My lord, it is P6 in the petition.
Page.
My lord, it was brought in by an amendment.
Hmm.
Probably not the
Yes, P6.
page 39.
हाँ. उद्देश्य एवं कारणों का कथन.
My lords. May I read the English portion? Statements of objects and reasons.
Page 49, I think.
39 says.
49.
39.
39.
ये श्वेत स्कॉलर ना,
ये
आशिता दुबे।
मतलब WP नंबर 5901
Yes, yes.
पेज 39.
No, this is the last document of the petition
My lord.
मतलब this is
at page 49.
मतलब this is annexure P6 which they have filed. मतलब annexure P6
P6.
in WP number 5901.
हाँ, हाँ. हाँ, वही last document
से
है.
ही रेफर कर रहा हूँ.
My lord, may refer to
Yes.
the record of Ashita Dubey, my lord, 5901.
आशिता दुबे
So that would be
जी,
Yes, yes.
उसका
आशिता
annexure P6 है साहब.
P6.
P6 is the last document of the petition.
My lords have the amendment.
It starts from 48.
I don't have the record of Ashita Dubey, my lord. I am.
Then 49, there's a Hindi version of the ordinance.
My lords.
It says उद्देश्यों और कारणों का कथन.
जी, जी.
हाँ, हाँ.
My lord, just come to the English version, my lords.
No, there's no English. आप हिंदी पढ़िए.
हिंदी
अंग्रेजी हिंदी भाषा अंग्रेजी से बेहतर भाषा है. Much qualitatively much better. हिंदी. हाँ.
मतलब उद्देश्यों एवं कारणों का कथन। अन्य पिछड़े वर्ग मध्य प्रदेश की कुल जनसंख्या के 27% हैं। यह वर्ग सामाजिक एवं आर्थिक रूप से पिछड़ा है। राज्य शासन में इस वर्ग के उत्थान के लिए कुछ योजनाएं तैयार की हैं, फिर भी उक्त वर्ग का सामाजिक एवं आर्थिक रूप से उत्थान नहीं हो सका। अतएव मध्य प्रदेश लोक सेवा मिलोट देन दे से दैट वी आर गोइंग टू मेक इट 27%। अतएव मध्य प्रदेश लोक सेवा अनुसूचित जातियों, अनुसूचित जनजातियों एवं अन्य पिछड़े वर्गों के लिए आरक्षण अधिनियम 1994 क्रमांक 100 की धारा 4 में यथोचित संशोधन द्वारा अन्य पिछड़े वर्गों के लिए लोक सेवाओं एवं पदों में रिक्तियों के आरक्षण के उपबंध 14% से 27% बढ़ाए जाना का विनिश्चय किया गया है। This is the object, my lords, and again they say that the population of OBC is 27%, and therefore the reservation is being made to 27%.
And then the act also came.
My lords, it's the same, my lords. The act also has the same objects and reasons.
Yes.
Now, my lords, therefore, my lord, the submission of the state as it comes forth is almost entirely based on quantifiable data to substantiate the enhancement of reservation from 14 to 27%, which makes the total reservation to 63%, but not excluding the EWS community, which could not have been done in any case in view of the specific findings and the law laid down by Indra Sahni's case, that it can't exceed 50% in any circumstances, not except for the circumstances mentioned in para 810. Now, Lord, before I take your lordships through, Lord, some portions of the Maratha reservation, Lords, which would require, Lord, a reading in the perspective of what I have, in the background of what I have submitted, Lords. My Lord, may just have one portion, Lord, which requires a specific answer is where the state's reliance on quantifiable data is. In paragraph 11 and 12, where the in the return, Lord, where the state seeks to rely upon quantifiable data, that is specifically answered, Lords, in para 382, 383 and 384 of Maratha reservation. Lords. My lords had seen up to, my lords, para 381 with in a different context, my lords, with reference to the judgment in Thomas and Akhil Bharti. Lord, 382 is most relevant.
382 was cited earlier.
My lords. And that is at page 216. The reliance placed by the state is on S.V. Joshi's judgment, my lords. S.V. Joshi is 2012 7 SCC, my lords, which is referred to in para 11 of the return, my lords. That is where this comes in, my lords. One more judgment delivered after Indra Sahni has been relied upon by Shri Rohatgi is S.V. Joshi versus State of Karnataka. Shri Rohatgi submits that this court in S.V. Joshi in para 4 referring to M. Nagaraj versus Union of India held that if a state wants to exceed 50% reservation, then it is required to base its decision on quantifiable data. In para 4 of the following law, following was laid down. Subsequent to the filing 16 of the Constitution have been amended, while Constitution 93rd Act 2005 and 81st Amendment Act 2000 respectively. That's the specific stand of the state also. Which amendment acts have been the subject matter of the subsequent decision of this court in M. Nagaraj versus Union of India and Ashok Kumar Thakur versus Union of India, in which inter alia it has been laid down that if a state wants to exceed 50% reservation, then it is required to base its decision on quantifiable data. In the present case, this exercise has not been done. Then 383 minutes. The observation was made in para 4 as noted above that the Constitution bench in M. Nagaraj has laid down that if a state wants to exceed 50% reservation, then it is required to base its decision on a quantifiable data, which is a clear misreading of the judgment of the Constitution bench of M. Nagaraj. In M. Nagaraj, the Constitution bench has not laid down any proposition to the effect that if the state wants to exceed 50% reservation, then it is required to base its decision on quantifiable data. To the contrary, the Constitution bench of this court in M. Nagaraj has reiterated the numerical benchmark like 50% rule in Indira Sahani case. The following observations were made by the Constitution bench in para 120 and 122 of M. Nagaraj. 120, in addition to the above requirements of this court, in Indira Sahani has evolved numerical benchmarks like ceiling of 50% based on post-specific roster coupled with concept of replacement to provide immunity against the charge of discrimination. We reiterate that the ceiling of 50%, the concept of creaming layer, and compelling reasons, namely backwardness, inadequacy of representation, and overall administrative efficiency are all constitutional requirements without which the structure of equality of opportunity in Article 16 would collapse. 384, the Constitution bench judgment of this court in Ashok Kumar Thakur has not laid down any proposition which has been referred to in para 4 of S.V. Joshi. This court's judgment of 3-judge bench in S.V. Joshi case does not support the contention of Sri Rogan.
Yes.
So, now there is no such finding in Nagaraj or the law laid down in Nagaraj that that's what the Honorable Supreme Court says. That for breaching the rule of 50%, for quantifiable data can be produced by the state to show inadequacy of representation.
Yes.
Inadequacy of representation with quantifiable data would be relevant to enhance reservation provided it remains within the limit of 50%. Now, not some paragraphs of this judgment in Maratha reservation. Note, Maratha reservation judgment is delivered by 5 honorable judges of the Honorable Supreme Court. There is part dissent and partly concurring votes. Not that part, because to bring out the single common measure, Lord, as was there in the other case. In this case also, Lord, with regard to Indira Sahni, it was thought to be argued that there was difference of opinion in Indira Sahni and there is no such rule as 50%. So the Honorable Supreme Court extracted the single common measure from the judgments of the various honorable judges to say that 50% rule has been upheld by all the judges, Lords. In this case also, Lord, that single common measure has to be extracted, not just to find out whether on the points which are relevant to this case, what is the opinion of the 5 honorable judges, not because they have delivered different judgments. My Lord Justice Ashok Bhushan's judgment would start from paragraph 229. My lords, I have para 229.
220.
229, my lords.
Yes, sir.
My lord, this judgment is for himself and for Justice Abdul Nazir, my lords. The questions which are framed are in para 237. There are 3 separate judgments which are delivered, my lords. One is by my lord Justice Ravindra Bhatt, one by Justice Nageshwar Rao, and one by Justice Ashok Bhushan.
Yes.
My lord, we just come to para 237, where the questions are framed. The first 3 questions are relevant, my lord, for this case. It is, my lord, whether the, my lords have 237, whether the judgment in Indira Sahni versus Union of India needs to be referred to larger bench or require a relook by the larger bench in the light of subsequent constitutional amendment judgments and change social dynamics of the society, etc. Second, whether the whether Maharashtra state reservation of seats for admission in educational institutions in the state and appointments in public services and posts under the state for socially and educationally backward classes SEBC Act 2018 as amended in 2019, granting 12% and 13% reservation for Maratha community in addition to 50% social reservation is covered by exceptional circumstances as contemplated by the Constitution Bench in Indra Sahni case. Third is whether the state government, on the strength of Maratha State Backward Class Commission report chaired by MC Gaikwad, has made 12, well, it should be made out a case of existence of extraordinary situation, exceptional circumstances in the state to fall within the exception carved out in the judgment in Indra Sahni case. Now, my lord, with reference to this, my lord may just come to the judgment which is delivered by Justice Ravindra Bhatt at page 62, where it is said that there is a concurring opinion of all the judges on questions 1, 2, and 3.
Hmm.
Page 62 minutes. My Lord Justice Ravindra Bhatt's judgment starts. My Lord may have para 8 at page 64. Para 7 again spells out those questions notes. Then para 8, my Lord, it says, I have the benefit of reading the draft judgment of Ashok Bhushan J, which has exhaustively dealt with each point. I am in agreement with his draft and the conclusions in respect of points 1, 2, and 3. So it says I am in agreement with the draft and the conclusions in respects of point 1, 2, and 3. In addition to the reasons in the draft of the judgment of Ashok Bhushan J, I am also giving my separate reasons in respect of point 1. I am, however, not in agreement with the reasons and conclusions recorded in respect of points 4 and 5, for which, my lord, reasons have been given separately. So on point 1, 2, and 3, the judgment by my Lord Justice Ravindra Bhatt and Justice Nageshwar Rao and Hemant Gupta, my Lord, the judgment being Ravindra Bhatt and Hemant Gupta delivering a common judgment, Justice Nageshwar Rao concurring with that, and they then concur with the judgment given by Justice Ashok Bhushan and Justice Abdul Nazir on points 1, 2, and 3. So there is total uniformity of opinion, my lord, so far as points 1, 2, and 3 is concerned among all the honorable 5 judges.
All right.
But now, my lord, the relevant portions with regard to the issues involved in the present case would start from page, my lord, 206, para 252. There were 10 reasons which were argued.
So all 5 had the same view.
All 5 have the same view so far as points 1, 2, and 3 are concerned. My lord, points 4 and 5, I haven't read over to your lordships. My lord, they are dealing specifically with the commission report of Maharashtra. So they are dealing with the fact situation of that case. So we are not probably required to go into that. Points 4 and 5, my lord, I'll just read over to my lord, so that there is clarity on that, my lord. 4, 5, and 6, my lord. Whether the Constitution, so and so Amendment Act, deprives the state legislature of its power to enact legislation determining the social economic backward classes and conferring the benefits on the same community under its enabling power, my lord, which we are not concerned with in this case. Whether the state's power to legislate in relation to any backward classes under Article 15.4 and 16.4 in any way abridged by Article 342A read with Articles 366, 26C of the Constitution of India, and whether Article 242A of the Constitution abrogates states' power to legislate or classify in respect of any backward class of citizens and thereby affects the federal policy structure of the Constitution of India. My lord. So I in fact stand corrected. My lord, the issues are all constitutional issues which are not involved in the present petition.
So the questions, those 5 questions are in which para?
My lord, the 5 questions are in para. I'll just point out notes. My lord, 237. In Justice Ashok Bhushan's judgment and para 7 of Justice Ravindra Bhatt's judgment.
37. What is 7 and?
My lord, para 7 of Justice Ravindra Bhatt's judgment. Para 7 and 237 are exactly the same. They just enumerate those 5.
This numbering is in continuation, na?
My lords.
Huh?
They are not in continuity. They are same reproduction of the same thing at 2 places.
No, no. The paragraphs are in continuation.
They paragraphs.
They don't break when
No, they don't break.
the author changes.
My lords, they don't break.
All right.
They don't break.
Yes. Yes.
So, my lord, 10 points were argued to seek reconsideration of Indira Sahni's judgment, my lords,
Hmm.
that your lordships would find in page 194. And answering those, my lord, elaborate reference has been done for, my lord, for the judgment of Indira Sahni. And finally, it has been concluded that it does not require any reference to the larger bench. My lord, may just come to page 194. 10 grounds for referring Indira Sahni's judgment to a larger bench. My lords have it. 194. These are the 10 arguments, my lord. I am not going into that. My lord, may come to page 206, where the consideration
we are
of
not concerned with 4, 5, and 6. Is it not?
we are not concerned with 4, 5, 6.
Basically, it is 1, 2, and 3. only.
1, 2, and 3. Those constitutional issues are not involved here. My lords have page 206,
Yes.
where there is consideration of those 10 grounds urged for revisiting and referring the judgment of Indira Sahni to a larger bench. Lord, this is where the discussion and elaborate explanation of that judgment starts. My lord, may come to 353. We shall proceed to consider the grounds given by Mr. Mukul Rohatgi in seriatim, which shall also cover the
No,
grounds.
this we have read.
My lord.
This had been read yesterday.
Lord, there will be some overlapping of the reading. Lord.
Finally, they said that there is no need to refer.
They did say, my lord, there is no need to, but on the various aspects which are raised in the return by the state,
They have reproduced that Indira Sahni's case.
my lord,
Extracts of Indira.
they have extracted and explained. But I'll just come to the parts, my lord, which probably would be of greater importance. My lord.
Hmm.
My lord, may come to page 209, where the common measure is extracted. Greatest common measure.
Page?
My lord, page 209, para 362.
Oh. Yes.
It reads, the above opinion of Sawant J is completely in accord with the opinion expressed by BP Jeevan Reddy J. In paragraph 809 and 810. The opinion of Sawant J expressed in the above paragraph is that ordinarily the reservation under Article 16.1 and 16.4 should not exceed 50%. And it is only in extraordinary circumstances that this percentage may exceed, which is also the opinion expressed by BP Jeevan Reddy J. Applying the principle of the Constitution bench of this court in Raj Narayan Singh, the opinion embodies the greatest common measure of the agreement between the opinions expressed. Thus, the majority opinion of the ratio of the judgment of Indira Sahni as expressed by the majority is one which is expressed in para 809 and 810 of the judgment of BP Jeevan Reddy J. The submission of Mr. Rohatgi cannot be accepted that majority opinion of Indira Sahni is that 50% can be breached. Then my lord may just skip over, my lord, to 364. Thus, the greatest common measure of agreement in 6 separate judgments delivered in Indra Sahni is that reservation under Article 16.4 should not exceed 50%. For exceeding the reservation beyond 50%, extraordinary circumstances as indicated in para 810 of the judgment of BP Jeevan Reddy J should exist, for which extreme caution is to be exercised. Then 365, the above is the ratio of Indra Sahni judgment. We thus do not find any good ground to revisit Indra Sahni or to refer the same to a larger bench on the ground urged. Then my lord may just, my lords have already seen 381, 382, 383 with in different context notes. My lord may just come to para 415 also, where there is emphasis as to what Indra Sahni has laid down as a rule. It's a small paragraph, 3 lines.
Please, para?
415. But when the Constitution bench in Indra Sahani held that 50% is upper limit of reservation under Article 16.4, it is the law which is binding under Article 141 and to be implemented. Just that part. And note that there is no difference between Articles 15 and 16 for the purpose of reservation is in para 423. The discussion starts from para 421 minutes. 423 is where it concludes. My lords have. Clause 4 of Article 15 is also a special provision which is nothing but reinstatement of the principles of equality enshrined in Article 14. The principles which have been laid down in para 808 with respect of Article 16.4 are clearly applicable with regard to Article 15.4 also. In the majority judgment of this court in Indra Sahani, the Balaji principle, that is 50% rule, has been approved and not departed with. The 50% principle, which is initially spoken of in Balaji, having been approved in Indra Sahani, we fail to see as to how prepositions laid down by this court in Indra Sahani shall not be applicable to Article 15. So, my lord, the same principle has been applied both to Article 15 and to Article 16.
Yes.
Not then to the one aspect which would be argued by the state is with regard to extraordinary circumstances. To bring it within the exception of para 810, my lords may have page 440, para 445 of this judgment. As to what the argument is and how it fits into the argument of the state also and how it has been answered. It is at page 236. My lords have it. Shri Rohatgi submits that in para 810 of the judgment of Indra Sahani, certain extraordinary circumstances have been referred to, which cannot be said to be cast in stone. The extraordinary circumstances provided in para 810, that is far-flung and remote areas, cannot be cast in stone forever unchanging. He submits that the same was given only by way of example and cannot be considered exhaustive. Moreover, it is geographical test which may not apply in every state. In para 810, then 810 is reproduced notes. 446. We fully endorse the submission of Shri Rohatgi that extraordinary situations indicated in para 810 were only illustrative and cannot be said to be exhaustive. We, however, do not agree with Mr. Rohatgi that para 810 provided only a geographical test. The use of the expression on being out of mainstream of national life is a social test which also needs to be fulfilled for a case to be covered by the exception. Lord, this last sentence is very important. That to be covered in the exception in para 810, the state has to establish that the community for which they are seeking to enhance the reservation to breach the 50% limit is out of the mainstream of national life. 447. We may refer to 3-judge bench judgment of this court in Union of India versus Rakesh, where This court has had occasion to consider the provisions of the fifth schedule of the Constitution, Article 243B, and provisions of Part 9 of the Constitution inserted by the 73rd of Constitution Amendment Act 1992. Reservation of seats was contemplated in statutory provision. The judgment of Indira Sahni, especially para 809 and 810, were also noted and extracted by this court. This court noted that even the judgment of Indira Sahni did not recognize the need for exceptional treatment in such circumstances. In para 44 of this court held that the case of panchayats in scheduled areas is a fit case that warrants exceptional treatment with regard to reservation, and that rationale of upper ceiling of 50% for reservation in higher education and public employment can be readily be extended to the domain of vertical representation at the panchayat level in the scheduled area. So that was, my lord, what was sought to be provided. Then, my lord, may skip over to para 448. Next page, please. Again, with reference to scheduled areas, please. This court carved out one more exceptional circumstance which may fit in extraordinary situation as contemplated by para 810 of Indira Sahni case. We may also notice that the constitution bench of this court in K. Krishnamurthy versus Union of India in para 82(4) applied 50% ceiling on vertical reservation in favor of scheduled caste, scheduled tribe, other backward classes in context of local self-government. However, it was held that exception can be made in order to safeguard the interest of scheduled tribes located in scheduled areas. Para 82(4) is as follows. The upper limit of 50% vertical reservations in favor of SC, ST, OBCs should not be breached in the context of local self-government. Exceptions can only be made in order to safeguard the interest of the scheduled tribes in the matter of representation in panchayats located in scheduled areas. 449 note, the judgment of the Constitution bench in the above case had approved the three-judge bench judgment of this court in Union of India versus Rakesh Kumar in para 67, which is also has the which is to the following effect. In the recent decision reported in Union of India versus Rakesh Kumar, this court has explained why it is necessary to provide reservation in favor of scheduled tribes that exceed 50% of seats in panchayats located in scheduled areas. However, such exceptional circumstances cannot be invoked when we are examining the quantum of reservation in favor of backward classes. This is very important for the purpose of local bodies located in general areas. In such circumstances, the vertical reservation in favor of SC, ST, OBCs cannot exceed the upper limit of 50% when taken together. So, my lord, it was said that for STs, for scheduled areas, the limit can be breached. That can be an exceptional circumstances. That cannot be used to provide OBC reservation to exceed 50% in normal areas, my lord, which are not scheduled areas, non-scheduled areas. Then para 450, we are thus of the view that extraordinary situations indicated in para 810 are only illustrative and not exhaustive, but para 810 gives an indication as to which may fit in extraordinary situation. 451 and 52 also. In view of the foregoing decisions, we do not find any substance in the ground raised by Shri Rosgi for revisiting the judgment in Indira Sahni. Then the report is considered, Lord, from para 459 onwards in that case. Lord. Only certain portions are required to be, Lord, which are important as to draw parallels between the Maratha case and our case, Lord, before my lords. How the commission interpreted, my lord, wrongly interpreted Nagaraj judgment in Maratha case, which was corrected by the Honorable Supreme Court, and how in the present case, my lord, the Mahajan Commission has wrongly interpreted the constitutional provisions and wrongly read Balaji's judgment. Para 462, my lords.
Yes.
After noticing the above proposition of law, the commission proceeded to deal with the subject. In para 234 of the commission has noted the constitution bench judgment in M. Nagaraj versus Union of India, observing that the court has again considered the aspect of ceiling of 50% reservation. The commission has, however, proceeded with an assumption that in Nagaraj, this court has ruled in favor of relaxation, that is 50%. There should be quantifiable data and contemporary data. We may notice the exact words of the commission in para 234, which is to the following effect. My lord may skip over, lords, what is said. To para 464. From the above, it is clear that the commission read the constitution bench judgment of this court in Nagaraj, laying down the ceiling of 50% reservation may be exceeded by showing quantifiable contemporary data relating to backwardness. The above reading of constitution bench judgment of the commission was wholly incorrect. We may again notice the judgment of M. Nagaraj in the above respect. M. Nagaraj was a case where the Constitution 85th Amendment Act 2001 inserting Article 16(4)(a) was challenged on the ground that the said provision is unconstitutional and violative of the basic structure. Then 16(4) is extracted. Not 465. The Constitution bench proceeded to consider the submissions raised by the petitioner challenging the constitutional validity of the constitutional provision. The Constitution bench in Nagaraj has noticed the maximum limit of reservation in para 55 to 59. The Constitution bench has held that the majority opinion Indra Sahni has held the rule of 50% was a binding rule and not not a mere rule of prudence. In para 58 of the Constitution bench judgment in Nagaraj is as follows, then 58 is quoted. My lord, we skip over to 467, where one very important paragraph, para 123, which is already read over to my lords. Only the last 3 lines of this may be relevant. Just for recollection. Last 3 lines of this note, it is made clear that even if the state has compelling reasons as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling limit of 50% to obliterate the creamy layer.
Where are you reading?
I am reading para 467, which has quoted para 123 of Nagaraj. Last 4-5 lines, it is made clear that even if the state has compelling reasons, the earlier part of 123 is with regard to quantifiable data, and this is where it concludes. It is made clear that even if the state has compelling reasons as stated above, the state will have to see that its reservation provision does not lead to excessiveness so as to breach the ceiling limit of 50%.
All right.
Just 15-20 minutes more, I'll conclude tomorrow.
Some more time.
No, just to sum up everything. And a few more paragraphs from this judgment. That would be all.
No, there is a special bench, so we'll have to get up
My lord, tomorrow may I continue?
tomorrow.
I am so much.
जैसे कल ऑर्डर किया था वैसे.
Tomorrow at what time?
After the list. Oh.